Yes, sir, I can hear you clear.
Okay. We're on the record 21 CCR 221014 and 21 CCR 221009, State of Texas versus Antoine Jermaine Davis Bay. Mr. Bay, this is your motion to reconsider. I've reviewed your motion to reconsider. I've reviewed the response and then your reply to the response as well. I'm going to permit 10 minutes per side for argument, and then I'll make a ruling at that time. So, Mr. Bay, you may proceed with any argument you'd like to make.
Okay. So this situation stemmed from an arrest from March 8, 2021, from a lawful arrest without a warrant. Sorry about that. Okay. This is a situation between hypothetical suspicion versus a concrete crime. Whereas in this situation, no concrete crime that took place prior to the unlawful traffic stop. Okay, the state has failed to even establish a probable cause for a warrantless arrest and search, and they had no justifiable basis exist to continue prosecuting this case. The charges of this case do not meet the requirements of actual concrete criminal activity as defined under Texas law and federal law. For one, the absence of a sworn affidavit of probable cause by the arresting officer further renders this arrest unlawful. An injured party or a complaint with a legally recognized injury.
Hey, Mr. Bay, my court reporter is having a difficult time understanding. If you would face the camera, that way your voice could be heard clearly. Thank you, sir.
Okay. Can you hear me clearly now?
Yes.
Okay.
Just maybe slow down just a hair on your speech. Thank you, sir.
Okay, no problem. Okay, I'll just repeat what I said. So this situation happened from an unlawful traffic stop.
Today, we're in a Texas courtroom where a self-proclaimed sovereign citizen from the Moorish movement thinks he can outsmart the system and toss out his own case. Judge Christopher Morales stays calm, professional, and completely unfazed by the legal gibberish. The twist? Mr. Davis Bay insists his arrest was illegal and the traffic stop invalid because, in his mind, no real crime happened, backing it up with random laws and federal rulings that don't even apply.
Also, I want to point out the fact that this is a case of hypothetical suspicion versus a concrete crime. Okay, the mere act of a traffic stop does not constitute probable cause for a broader detention or search as recognized by Terry versus Ohio. Okay, hypothetical suspicion does not equate to criminal behavior. Okay, in Texas, arrest was searched without evidence of a crime of probable cause contravenes Texas Code Criminal Procedure Article 14.01, Section B, which requires that an offense be committed in an officer's presence or viewed to justify a warrantless arrest. The officer, Jazz Roberts, who was the arresting officer at that time, he did not have any probable cause or reasonable suspicion to even initiate the stop. And then once the stop was initiated, he didn't have any authority to continue with a search or an arrest, especially not just based off of mere traffic citation. Like I noted, that traffic citation was dismissed, okay, indicating that they didn't have any probable cause to prosecute a traffic citation against me. And also, the adjoining case that was with it was a possession of marijuana, which was dismissed.
This is where things start to go off the rails. Mr. Davis Bay argues that because his marijuana charge was dismissed, the entire traffic stop must be invalid. But that's not how criminal law works. The legality of a stop depends on whether the officer had reasonable suspicion at the time, not on whether charges get dropped later. A dismissal doesn't magically erase the officer's authority to pull you over.
In Texas, due process violations occur when the rights to fair and impartial hearings are denied as well. And this is on the Texas Constitution, Article 1, Section 19. Okay. Also, the officer, as I mentioned, failed to sign an affidavit of probable cause, which is required under Texas Code of Criminal Procedure, Article 1505, subsection 2, which mandates that a written statement establishing sufficient factual grounds for arrest be presented and signed by the arresting law enforcement officer, which I requested a police report from Rosenberg Police Department, which is the arresting agency. I uploaded the results of what I received of that, which is pretty much a blank report. And it failed to have any attached affidavit of probable cause with it. Also, the prosecutor in the last hearing presented me with a discovery, which also failed to present any affidavit of probable cause. Okay. Okay. Also, unlawful search and seizure falls under Texas Criminal Procedure, Article 38.23. Okay. The prosecutor alleged the odor of marijuana. The odor of marijuana alone, without physical evidence of probable cause of actual crime, is insufficient to justify a vehicle search. Once again, was no testimony or affidavit of probable cause to.
Honor, if I may, I'm going to object to this. This is outside the scope of the hearing.
Sustained. Let's stay within the scope of your motion.
Listen to how confidently he fires off legal citations. Article 14.01, Section B, Texas Code of Criminal Procedure. Sounds impressive, right? Until you realize he's using them completely out of context. Sovereign citizens love to weaponize legal jargon without understanding it. It's like quoting the dictionary to win a spelling bee. It sounds smart, but proves nothing. The judge just stays calm and lets him talk himself into a corner.
The fruit of poisonous tree doctrine, and that's Wong Sun versus United States, followed by citation. This doctrine.
Yeah, Mr. Bay, can you spell that name for my court reporter, please?
Yes, ma'am. Yes, sir. Wong Sun is W-O-N-G, first name, last name Sun, S-U-N. That's versus United States.
Thank you.
You can continue now. Thank you.
Okay. This doctrine bars evidence obtained from unconstitutional actions, including unlawful stop searches and arrests like probable cause. So for these reasons, I request that the court grant this motion for reconsideration to the motion to dismiss for lack of subject matter jurisdiction based on the due process violations, lack of probable cause, and other evidence that's lacking as well. Warrantless arrests, like as I mentioned in my motion and also in my brief. Okay, and I also request that if this motion is not granted, that I could get a full and complete police report to prepare for a defense. Also, evidence supporting the traffic stop and alleged crime that gave rise to this these charges that I'm facing with the evasion of arrest and charges of unlawful possession of a firearm. Because for it to be an evasion of arrest, it has to be grounds for an arrest for me to invade. There's no evidence of this. So with the incompleteness of discovery by the state and the failed documentation that the prosecutor failed to provide with a record of events that would normally be captured in a police report, I am prejudiced from preparing a defense, and I'm deprived of crucial information necessary to challenge the validity of the stop and subsequent search. So I do compel that full discovery, and I do request that this matter be dismissed for the reasons stated before.
And here it is, the moment every judge dreads. A pro-se defendant arguing everything except the motion at hand. The judge sustains the objection and basically says, stay on topic or we're not getting anywhere. This is where experience matters. Lawyers know the limits of a motion hearing. Sovereign citizens don't. Instead of persuading the court, he's burying his point under a pile of irrelevant legal jargon.
It was
Will you
Okay.
spell that, sir?
last baby@gmail.com.
And Mr. Bay, is that the same email address that we have received responses from you on October 23rd, November 6th, and November 13th?
Yes, it was.
That is the same email address the state sent you discovery, which would include the PC affidavit that was signed by the arresting officer, as well as the complete offense report that you just told the judge that you did not have access to. That information was shared with you to that email that you just confirmed on October 19th.
I never received any email with a police report, and I requested the police report over 2 years ago.
Did
So
you
the police,
request it? Who did you request it from?
the Rosenberg Police Department.
Okay. Please send me, I will do my best, but please send me an email immediately following this hearing so that I can provide you a PDF of that document so that we're not going through our portal.
Okay, no problem.
Now, in response to some of these statements or allegations made by defense, again, as I just made clear, the defense has had access to the discovery since at the very least October 19th, 2024. I can't speak to whether the previous prosecutor had shared any of the discovery. I know he was admonished, I believe, on the same date that the docket control order was signed. So we haven't been able to go through actual defense counsel for this, Judge. Again, I will send over in an alternative format the PC affidavit and the offense report so that the defense has access to a complete set of information. On the last setting, I believe it was November 7th, defense was provided copies of all the media, Your Honor. So he does have access, at least from my understanding, to all the discovery. Now, as to points made in his motion, first and foremost, Mr. Bay has not been charged by information with evading arrest. Mr. Bay has been charged with fleeing a police officer as well as a unlawful carrying of a weapon. Now, to his first point of hypothetical suspicion, I do not know where the defendant finds that within the case law. I have not found anything of hypothetical suspicion. What justifies a traffic stop in this particular case is reasonable suspicion. As seen in the PC affidavit, as well as the offense report, the officer had a on-view offense for a traffic citation, which was speeding. The officer attempted to conduct a traffic stop for said speeding, at which time the defendant failed to pull over as required by Texas law. That in and of itself constituted fleeing a police officer, which is in violation of the Texas Transportation Code. I believe it is section 545.421. At the time of the stop, the officers attempted to make contact with the defendant. They observed an odor of marijuana. There is case law stating,
If this case shows anything, it's that representing yourself with YouTube-level legal knowledge is a fast track to failure. Mr. Davis Bay keeps citing fruit of the poisonous tree, but that only applies if the original stop or search was unconstitutional, which it wasn't. Now he's demanding dismissal over so-called missing discovery, even though the court already gave him everything. It's a classic sovereign citizen move. Bury the record in complaints, then claim the system's unfair. Judges see this all the time. The louder the argument, the weaker the case.
Based upon the odor of marijuana, a probable cause search was conducted on the vehicle. Again, this is as alleged by the state, at which point in time, the weapon was discovered within the vehicle as well as the contraband itself. I do not know, again, going to one of the points defense made, I don't know what due process rights are being violated here, which would warrant either suppression or a dismissal as defense has requested. He's claiming that he has not had the right to a fair hearing. PC was found by the magistrate at the time defense or the defendant bonded out. The state has provided copies of that bond paperwork, which was also sent to the defense at the time all discovery was shared. Again, I will re-provide that to the defendant in an alternative way. PC was found by the magistrate. So he's claiming he has not had he hasn't had a fair hearing, but the magistrate found PC at the PC hearing at the time that he bonded out. So I'm not quite sure what fair hearing he's alleging he has not had a right to. I know he also made reference to not being able to confront witnesses against him in his motion. We have not had a trial yet. No witnesses have been presented for cross-examination. I will say, and obviously I will provide this to the defense electronically, Your Honor. I wanted to, at the very least, bring this to the court's attention. I have two cases. First is Born, B-O-R-N-E, v. State. Citation is 593 Southwest 3rd, 404. I have a copy of it for the court. May I approach?
You may. Did you get that citation, Mr. Bay?
If this case proves anything, it's that representing yourself with YouTube-level legal knowledge is a one-way ticket to disaster. Mr. Davis Bay keeps throwing around fruit of the poisonous tree, but that only applies if the original stop or search was actually illegal, something he never proves. Instead, he doubles down, demanding dismissal over an incomplete discovery process, even though the court already gave him everything. Classic sovereign citizen playbook: flood the record with noise, then cry unfairness. Judges have seen it all before. The louder the defense, the weaker the case.
Courts. In Lewis v. State, they make a similar point. And in that particular point, or in that particular case, rather, the judge appointed standby counsel for the defendant. The state wanted to at least put this on the court's radar in that there are certain concerns the state has based upon the filings made by the defendant, in that one of two things is either occurring. Either the defense is filing frivolous motions to delay the judicial process and attempt to coerce the state into dismissing these charges, or alternatively, the defense is unfamiliar with the judicial process. If the latter is the case, the state would be concerned if the defense wasn't provided standby counsel. That's what Lewis v. State is about, Your Honor. Obviously, it is up to the defendant and it is up to the court, or the court's discretion, rather. If the defense is going to claim that he's having a bunch of rights violated, I would want to guarantee that we protect these rights as strongly as possible. Again, if the defendant were so inclined.
And that right there seals it. The officer stopped him for speeding, a clear Texas traffic violation, and when he refused to pull over, that alone became another charge. Add in the smell of marijuana, and the officer had full probable cause for a legal stop and search. So the next time someone claims to be a sovereign citizen, remember, the courtroom doesn't run on internet theories. It runs on evidence and law.